All right, members, let's resume the meeting. We are going to part 44. Please, Mr. Lee, please let us know who will walk us through this part. Thank you, Madam Chair. Next, the amendments are related to environment protection, Environment and Ecology Department. We'd like to invite Ms. Zhao to walk us through part 44, that is CAP 466B. Chinese version is page 208. English text is 215. Ms. Zhao, please. Thank you. We propose amendment to CAP 466B and to make amendments to its Schedule 2. Chinese version is page 208 to 212. And the English text is 215 to 219. For the Chinese version, there is a mention of using land registry to replace the outdated urban land registry. The amendments are straightforward and technical and non-controversial, and it will not have any substantial effect to the relevant legislation on reclamation areas specified for the purposes of Section 4, bracket 28. 208 to 212 Chinese text, or it's regarding the repeal or crossing out of the word urban on the English version. Yes, correct. All right, members, please go through these pages, 208 to 212 Chinese text, 215 to 219 English version. Any question? If not, let's move on. Thank you, Madam Chair. Next, it's also related to environment and ecology. It's part 56 regarding the protection of endangered species of animals and plants ordinance, CAP 586. Mr. Ng Ka-chen, the PAS. Thank you, Chair. Part 56. Government strive to protect endangered species of animal and plants. We work according. I'm sorry, which part are you on? A Chinese version? What pages? All right, sorry, Madam Chair. Chinese version 330. 330. 330 Chinese version. Reason why we make this proposed amendment is because we work according to the. I'm sorry, can you speak louder, please? Well, according to the international trade ordinance. And through the endangered species of animals and plants ordinance, we are applying the international ordinance to the Hong Kong environment. So CAP 586 has set out the names of the various endangered species, and we also, according to the international standards, add the popular names of the endangered species, and also sometimes the names used by the relevant of the country or region in which these endangered species are found. And our proposed amendment is on the names of those endangered species. In order to avoid confusions, we have drawn reference from the international organizations and using the names of these endangered species. So we propose to amend the popular names of these endangered species. It's just straightforward and technical and will not affect the content of the ordinance. Page 330 of the Chinese version, in section Schedule 1, we have made amendment of the Chinese version 孟加拉國 to 孟加拉. 331 Chinese text 無理求思, we have made a change in the Chinese, the writing of the word 求. And also Chinese 332, page 332, 無理求思, the word 求 has amended into another Chinese word of 求. And also 3貝里斯 百里茲, and this is a change of the Chinese writing of those words. 340 玻利維亞國 change into 玻利維亞, and 貝里茲 change into 百里茲 on the Chinese text. Thank you, Madam Chair. All right, no questions from members. Let's move on. Mr. Lee? Next, it's about Part 45 on the proposals made by the Judicial Administration. Chinese version 213, English 220. Mr. Lau? From the Judicial Administration, please. Section 116, Chinese 213, English text 220, page 220 of the English text. Section 49, we propose to repeal the entire section. It's a transitional provision. 49 bracket 1, it's about any appeal in respect of which the Judicial Committee of the Privy Council or the Court of Appeal has granted conditional, final, or special leave to appeal to that committee, and the appeal has not been finally disposed of on or before 30th of June 1997, shall proceed in the court, and the court may give such directions as to the continuation of the prosecution of the appeal as it thinks fit, and shall have full power to determine by whom and the extent to which costs in relation thereto are to be paid. Bracket 2, it's also about reference to a final or interlocutory judgment of the Court of Appeal under Section 22 bracket 1, and to a final decision of the Court of Appeal or the Court of the First Instance under Section 31 includes a reference to similar judgments and decisions of the Court of Appeal and the High Court made before 1st of July 1997. That is bracket 2 of Section 49. So the entire Section 49 are transitional provisions. So after 1997, these arrangements are outdated and all the courts have been processed. So we propose to repeal the entire Section 49. Thank you, Madam Chair.
Hey.
Yes, Mr. Porche. I, in principle, do not object to the proposed amendments. However, I have a question about consistency. Apart from this ordinance, there are transitional provisions in other ordinances. If these provisions are no longer in use, Well, take this as an example. There are no substantial impacts if we are to repeal the transitional arrangements. However, from a policy perspective, how long do we have to wait until we remove a transitional provision that is no longer in use? I want to know why the government is proposing this amendment, as there won't be any impacts if we are to keep these provisional provisions. Mr. Lau. I thank the member for the questions. While we cannot apply a broad brush approach for certain transitional provisions, will they lose their effect after a certain period of time? This is not in the absolute sense. There are some provisions concerning time during the Japanese rule. We will look at those provisions later. Those provisions have been enacted for some 80 years. And there will no longer be any new cases that arise from the time during the fall of Hong Kong. And we can repeal those provisions. As for conveyance of land, those provisions concerned will still be in use even after 80 years. Well, my understanding is that there will no longer be such cases at the Hong Kong Court of Final Appeal. It's been years, and we learned from the judiciary that there are no more such cases. There is mention about the Privy Council in the provision, and it is not appropriate for us to retain the term here. So the simple way to deal with it is to repeal the provisions. I have a follow-up question. Does that mean every government term there will be transitional provisions that need to be repealed? This is a way to fix the irrelevant provisions. Does that mean within the current term government we have already dealt with all the provisions that are outdated? Is this a periodic project? Do you hold such exercise from time to time to repeal all the transitional provisions that are no longer in use? There are three parts to our adaptation exercise. As mentioned, for some provisions, if they are outdated or they need to be updated, we will do so. And this is just one part of our exercise. The priority now is to implement the adaptation. It's not that we are drawing a line here. We have to first identify the provisions that need to be adapted. And this time around, we have identified provisions that need to be adapted. And during the process, we also noticed provisions that are obsolete. That's why we're repealing them in one go. Clause 117. Page 214 to page 215 of the Chinese text. We are only amending the Chinese version. Section 5, bracket 2b and bracket 3b, there is mention about the district court. And after the reunification, there is a change in the Chinese rendition of district courts. So we are changing it from 地方法院 to 區域法院, which both means district council, a district court in the English. Clauses 117 to 121, they concern the same kind of amendment, so I'll give an explanation in one go. Please refer to page 216 to 219 of the Chinese text. and page 221 to 224 of the English text. Yes. There are references to the Supreme Court Cap 4 subsidiary legislation in these provisions. After the reunification, the name of the court has been changed to the Final Court of Appeal. So we propose replacing the Supreme Court to High Court Cap 4 subsidiary legislation A. There are such amendments from clauses 117 to 121. This is a technical amendment. Please move on. We are now at clause 122, page 220 of the Chinese text and page 225 of the English text. This is a consequential amendment. Under clause 116, we repealed Cap 49 and there is a reference to the Supreme Court again under section 76 here, so we are repealing that part. Please move on. Yes, Mr. Lee. Thank you, Madam Chair. Another amendment concerning the judiciary. Please refer to Part 68 of the bill. We are repealing certain enactments here. We propose to repeal Cap 9 and Cap 252 of the Hong Kong laws. Please refer to page 394 of the Chinese text and 409 of the English text. I will invite Mr. Lau from the judiciary to brief you on this part. Clause 234 of the bill proposes to repeal the certain enactments that which include the Judgments Facilities for Enforcement Ordinance. In 1921, this was enacted. The then British Empire and later the Commonwealth, the judgment made there can be enforced in Hong Kong. There was the reciprocal enforcement arrangement. And this applied to other Commonwealth countries. In 1960, under Cap 319 of the laws of Hong Kong, the reciprocal enforcement arrangement was established, and this has replaced Cap 9, the Judgments Facilities for Enforcement Ordinance. So Cap 9 is no longer applicable. We no longer adopt Cap 9. So we propose to repeal Cap 9 and all the relevant subsidiary legislations. Please move on. There are also other ordinances that have a historical background. That is the Enforcement of Rights Extension of Time Ordinance, Cap 252 of the laws of Hong Kong. Please refer to page 426. Yes, page 426 of the Chinese text. During the invasion of Japanese That is from the 8th of December 1941 to the 15th of January 1948. Well, this does not fall under the time when the leave for appeal was valid. So we are exempting that period. However, it's been some 80 years now, and the relevant provisions no longer apply. So we propose to repeal this ordinance. That's all from me. Mr. Lee? Please refer to Part 22. It has to do with the Health Bureau. And this concerns the Medical Registration Ordinance, Cap 161. Well, but Part 7 concerns the Labor and Welfare Bureau. Yes, my apologies. This should be Part 7, which concerns the Employment Ordinance, Cap 57 of the Laws of Hong Kong. Please refer to page 21 of the Chinese text and page 19 of the English text. I'll pass the floor to Ms. Lai from the Labor and Welfare Bureau. Thank you, Madam Chair. Clause 11 seeks to amend Cap 57. Section 50. Let's look at the Chinese version first. As mentioned, it should be page 22 of the Chinese text. This part regulates the employment agencies in Hong Kong, and Section 53 lists out the employment agencies that are exempted. There is a reference about Her Majesty's government or the Hong Kong government. This no longer applies. Her Majesty's, according to Cap 1, Section 2A of Hong Kong laws, should be construed as the Central People's Government. Therefore, Section 50, subsection 3 of Cap 57 will be amended. For the part about Her Majesty's government or the Hong Kong government will be amended to the Central People's Government or the government. Please refer to page 20 of the English marked up copy. Her Majesty's government, as mentioned, will be revised to the Central People's Government, and the Hong Kong government will be revised to the government. And this is an adaptation of the laws. There is no change to the policy. Mr. Lee, please carry on. Another amendment concerning the Labor and Welfare Bureau, Part 32 of the bill, the Adoption Ordinance, Cap 290 of the Laws of Hong Kong. Please refer to page 168 of the Chinese text and 167 of the English text. I'll invite the LWB to elaborate. Here, we propose to repeal Section 17, bracket 2C1 of Cap 290. Currently, the adoption order should comply with 3 criteria or conditions from overseas in order to make them applicable in Hong Kong. First, it has to be issued by a country. Also, the adopter should be given the priority compared to the biological parents. Also, the right of succeeding the estate of an adopted person should be the same as that of a child of a biological parent. Back in 1960, this provision was included in the adoption ordinance. That was to deal with the different governments of the Commonwealth countries that do not recognize the adoption orders issued in different countries, and we made reference to the laws of New Zealand. That's why we included the provision in the adoption ordinance. That's why there is mention about Commonwealth countries or countries of the US. In order not to affect the benefit of the adopted children, that's why we had the transitional provision, that is section 13.
The transitional provisions, it's on Chinese version 169, right? Yes, page 169. And for the English text, it's page 167 and 168. All right, let's move on. Mr. Lee? Thank you. Next, it's amendment related to the Medical Registration Ordinance, Part 22. On the marked up copy, please refer to the Chinese text, page 120, and English text is 119. I'd like to invite Mr. Lee to walk us through. Madam Chair, I'm Lee Tong-yan. We are on Cap 161, Section 2, and Schedules 3 and 4. We are just amending the terms that have historical backgrounds, for instance, that are relevant to the British legislation. In 1995 and before that, a person who is holding UK or Ireland medical qualification, he or she could be registered in Hong Kong as a medical practitioner. This special arrangement was passed by the previous Legislative Council in 1995, and there is a standardized professional registration examination. So all doctors that were not trained in Hong Kong had to sit for a registration examination. So this 1995 ordinance was enacted in August 1995 and in effect in 1st of September 1996. And the Legislative Council also passed another legislation. It's about professional provisions for the registration of medical doctors in 1997. The purpose of which is to allow students who were sitting for the registration examination, and this is a kind of transitional provisions. So here is to retain the legislation which was repealed in 1995 and to retain it as a kind of professional provisions. For those who were granted the professional qualifications 3 years after 3 years or within the 3 years after 1995. And also for those who have applied to sit for that examination before 1995 and who would apply for registration 2 years after 1995. It's applicable only to Hong Kong permanent residents falling under those categories. Well, this is a special arrangements for recognition of the UK medical qualifications. The legislation, since the legislation in question was enacted in 1995, those who apply for the qualification will have applied by 1998. That is 3 years after the legislation was in force. So after 1998, we had not received any such applications. And so we found that the relevant legislation is already obsolete. And that is why we propose to repeal these obsolete legislation. And also, as that provision was known to be a transitional provisions, we believe that it is the right time to repeal them as they are already obsolete. Please refer to the marked up copy, page 120 of the Chinese text, and page 119 of the English copy. Under interpretation, we propose to delete commencement, the definition for commencement and enaction date. Since these two definitions or these two terms refer to the amending ordinance, which took effect in 1995 and 96 respectively. So we propose to delete these two terms. Page 121 of the Chinese text. We also propose to delete three terms. First, amending ordinance. Second, original ordinance and original provisions. These are about the 1995 amendment ordinance. And the other one is about transitional arrangements for medical registration. The original ordinance was in force in 1995. So they are already obsolete. These are our proposed amendments to Section 2 interpretation. Next, page 162 about Section 70, about Clause 72. About professional registration, we propose to delete 1A. Section 12, professional registration, Clause 1A. For those who have already sat for the registration examination and who had to do an internship in Hong Kong, and for that purpose there was a professional register given to these persons. So these are provisional arrangements, special arrangements for these group of people. That is, when they return to Hong Kong, they will be able to obtain a professional registration. So we propose to delete clause 12, bracket 1A because of that, because it's already obsolete. Next, page 128 of the markup copy, clause 73. Section 1. About registration, any person entitled to be registered under this section and Section 35 bracket 7 may apply to the registrar for registration. Since Section 35 bracket 7 had been amended, so we propose to delete bracket 1. 131, page 131 of the Chinese text. Clause 74. We propose to amend Section 35, transitional. we propose to repeal Section 7, 8, and 9. The content of which is about these provisional arrangements for the people seeking medical registration in 1997. It's a transitional provisions. It's about persons who was registered within 3 years after the commencement of the legislation. Or persons immediately before commencement registered or enrolled to pursue a diploma. And bracket 8b sets out that this is applicable to Hong Kong permanent resident, and bracket 9 sets out a definition of recognized Commonwealth diploma. So we propose to delete these altogether. Page 133 on clause 75. What about the English version? Oh, English text is on page 132. Schedule 3, we propose to delete the original provisions under Schedule 3 and also under Schedule 4. Schedule 3, it's about the original provisions. Well, basically, it's for those students who return to Hong Kong, and they could, based on these original provisions, apply for professional registration in Hong Kong. Page 134, it's a continuation of Schedule 3. It's all the way to page 136. These were the original arrangements. For instance, there should be proof of professional experience outside of Hong Kong. And all these are the professional arrangements we propose to delete. Next, page 137 on the markup copy. It says schedule. It should be the Schedule 2, Schedule 3. What about English copy? English copy on page 136. It says schedule. It is actually the Schedule 2, Schedule 3. So as we propose to repeal Schedule 3, this Schedule 2, Schedule 3 should also be repealed. Next, page 138. Chinese text. This is Schedule 4. Schedule 4 sets out the recognized Commonwealth institutions or bodies. We propose to repeal the schedule altogether.
Anything else from Part 22? That's all from me. Mr. Lee. Thank you, Madam Chair. To give you a notice for Part 24 as well as Part 51, we will have the Law Drafting Division to walk us through the bill. Part 24 concerns the matrimonial proceedings and property ordinance, Cap 192. Please refer to page 140 of the Chinese text. Also page 140 for the English text. I'll invite Mr. Choi from the Law Drafting Division to walk us through this part of the bill. Thank you. Clause 77 of the bill amends the Matrimonial Proceedings and Property Ordinance Cap 192, Section 10, subsection 1A. The reference to 6 bracket A will be revised to 6 bracket 1 bracket A. You said there was an erroneous reference. That means the reference itself was wrong? Yes. Now we come to part 51. Please turn to page 255 of the Chinese text and page 264 of the English version. 255 for the Chinese text and 264 for the English. Please carry on. Part 51. That's clause 146. This is to amend the Discovery Bay Tunnel Link Regulation Cap 520A, Section A, subsection 2B. This is an amendment concerning the technical memorandum standards for effluents discharged into drainage and sewerage systems inland and coastal waters. We do not need the reference to Cap 358 subsidiary legislation. The technical memorandum is not a subsidiary legislation. It is only if it is a subsidiary legislation that we give it a number. It was erroneously given a number, so we are making an amendment here. That's all from me. Mr. Lee. Now the amendments concern the FSTB. It's part 2 of the bill. We are amending the Judicial Trustee Rules Cap 29B. There is no English amendment for this part, and for the Chinese text, please turn to page 1. I'll invite Mr. Low from the FSTB to walk us through this part of the bill. We made reference to Cap 1, Schedule 8, Item 21D of the Interpretation and General Clauses Ordinance. So here, under Sections 27, we are amending the term judge 大法官 to 法官. And for English, there is no amendment because we are keeping the term judge, and there is no policy change. Now we come to the next part, Mr. Lee. Part 3 of the bill concerns the Money Changers Ordinance, Cap 34. Please refer to page 2 of the Chinese text and page 1 of the English copy. I'll invite Mr. Chen from the FSTB to walk us through this part of the bill. Cap 34 sets out the currencies. Schedule 2 here, there is reference to country and territory. And for references to country and territory, after adaptation, we are amending them to country, territory, or place to expand the coverage scope. We are also taking the opportunity to amend the list under Schedule 3 to remove unnecessary provisions. Please refer to page 2 of the Chinese text. That's Schedule 2, Permitted Statements. Under Schedule 2, we propose to amend countries or territories currency to countries, territories, or places currency. I have a question. Page 3 of the Chinese marked up text. Currency currencies of the following countries, territories, or places, and there is a list of countries and territories. How do you arrange the names of these countries? For Schedule 3, we are amending a couple of references here. The first reference is about country or territory. We're amending it to country, territory, or place. As for the list of countries, territories, or places, we have the following amendments. First, we are amending the reference to China so that we know that it's about RMB. Also, we are removing the reference to France as well as Germany because their currencies have been replaced. Thirdly, we are adding 3 countries, territories, or places, including Indonesia, Vietnam, and the European Union. Based on the adaptation, we are replacing South Korea with Republic of Korea. We are replacing the United Kingdom in Chinese, and there is no English amendment. And we also have a change in the Chinese rendition of the United States of America, but there is no corresponding changes in the English version. Please carry on. Mr. Lee. We now come to Part 5 of the bill concerning the insurance valuation and capital rules, Cap 41R. Mr. Lee, please hold on. We are now at Part 5. It covers clauses 7 to 9. I'd like to invite the administration to walk us through clauses 7 to 9. Afterwards, I will invite Professor Priscilla Leung to speak about her proposed amendments. Then I'll have the administration respond to the proposed amendments from Professor Leung. Now, clauses 7 to 9. I'll invite Ms. Carol Wong from the FSTB to walk us through the principle. We are proposing to amend the insurance valuation and capital rules. Under the risk-based approach, insurers, when calculating the valuation and capital, there are certain rules that they have to comply with. Under the insurance valuation and capital rules, there are 3 major amendments. I'll first talk about the Chinese amendment first. Page 11 of the Chinese text, we propose to amend table 11. On the left-hand side, we are amending the reference to China mainland. We are amending it to China, Hong Kong, Macau, and Taiwan. They are exempted. Page 12. We are amending table 10. Again, there's the reference to mainland China. We're amending it to China, except Hong Kong, Macau, and Taiwan. Page 18 of the Chinese text, Schedule 8, Table 3. Again, there is reference to mainland China, and we propose to amend it to China, except Hong Kong, Macau, and Taiwan. Now I will talk about the proposed amendments in the English version. Please refer to page 10 of the English text. There are 2 proposed amendments. First, for the word Macau, we are changing the spelling from MACAU to the official spelling MACAO. Page 15 of the English text, we are amending Table 10. Again, we are revising the spelling of Macau and we are amending the reference to mainland China. Please carry on. Page 17 of the English text, we are amending Table 3 under Schedule 8 to the rules. Again, we are revising the spelling of Macau and we are amending the reference to mainland China. Thank you. I see that members have asked to speak. Professor Priscilla Leung. Thank you, Madam Chair. In relation to the proposed amendments, I think there are problems to the amendments. We want to decolonize our laws so that when the public looks at both the Chinese and English version of our laws, there won't be any misunderstandings or fragmented misunderstandings. Now you are amending mainland China to China bracket excluding Hong Kong, Macau, and Taiwan. In English, the revision is China bracket excluding Hong Kong, Macau, and Taiwan. This may give readers the impression that China does not include these three places. I don't have any specific views on the original version. In the context of laws, if Taiwan is covered, mainland China is acceptable. In many academic works, oftentimes we use the term mainland China. Well, I think it is inappropriate for you to use the word excluding in the English version. Originally, mainland China is quite clear to all of us. I hope that we can bring our heads together on this. If we are to amend this, I think it's okay to amend mainland China into China. So is it better to exclude the word mainland? Well, I think after the amendment, it does not look right. There might be misunderstanding if you look at it from the first glance. So I suggest that we do not amend this part. If you are to amend it, please do not include the phrase excluding Hong Kong, Macau, and Taiwan. I don't find this acceptable. This is my view.
Professor Leung, thank you for bringing up this point and making your suggestions. Your paper has already been distributed to members. Do you have... Actually, I'd like to thank you for your submitting these very useful suggestions. On the Chinese text, you mentioned either to keep the original rendition or for English. Do you have any suggestion? Well, for English version, using the term mainland China is totally acceptable. It's very clear. So the English text using mainland China is good enough. I'd like to hear any views from the Law Reform Commission or the administration. All right, let me perhaps talk about the background of this proposed amendment first. In 2024 miscellaneous provision amendment, some members suggested whether we should standardize the use of the term Chinese term 內地 or 大陸 in mentioning China. So we considered this suggestion and come up to the conclusion that if China and Hong Kong SAR is mentioned, we use 內地, and if Taiwan is involved, we use 大陸. Professor Leung has made it very clear. For the English version, mainland or mainland China do not have differentiation between whether it is the continental China or including the islands. So I agree to Professor Leung. That is, in for instance, in Cap 1 in Schedule 8, we have drawn reference from the NPC's decision in 1997 when Taiwan, Macau, and Hong Kong are mentioned. They would use the term 大陸 in the Chinese text. For Cap 41R, there is a special condition here because for this time, 4 places are placed together. So if they're placed together, shall we continue to use China, mainland China, or any other different terms? We'd like to thank Professor Leung for bringing up this point and also for submitting her suggestion in writing. So we would have some time to think about it and make some preparations for our proposal. We agree that in order to avoid confusion, when Taiwan, Hong Kong, and Macau are mentioned, we should make it clear that the rendering should be clear. So we should either retain the term China mainland or mainland China. Well, at the end, we also, upon drawing reference from other similar legislation, we have this decision. We use Hong Kong, Macau, and Taiwan. Hong Kong, Macau, places in China excluding Hong Kong, Macau, and Taiwan. In English, it's the part of China other than Hong Kong, Macau, and Taiwan. This will very clearly point out that when the 4 places are placed together, are mentioned at the same time, we are talking about the part of China that do not include Hong Kong, Macau, and Taiwan. So this is an alternative rendering. If members agree, then we would adopt this amendment. We will go back to discuss with our colleagues and put up with an alternative proposed amendment. Thank you, Madam Chair. Mr. Pose? Madam Chair, we have to flip through all the documents, so I may be a bit slow. When we're talking about Cap 34, it's about the currency, right? Cap 34. I will also compare it with Cap 41. All right. And Cap 34, when I look at the schedule, I understand that in English they use alphabetical order to decide the order of the countries. For instance, Australia comes first. But then in the Chinese version, they put China first. Perhaps they use the number of strokes of the Chinese words to decide on the order of the mention of these countries. Under interpretation For instance, Section 1, they would use the English order. For this kind of interpretation clauses, they adopt this ordering. It's quite rare to see that the ordering of these schedules in the Chinese and English versions are different. Well, of course, it would be clear to those who are proficient in both languages, but I'd like to know if this practice is intentional. Reason why I ask this question is because when we look at CAP 41, the ordering is different. They use the English ordering. Australia comes first, and then for the Chinese schedule, Australia, it's also top on the table. So I'd like to know whether it's made consistent. Mr. Lee? Thank you, Mr. Chair, for your question. The decision on the ordering of the mention of these countries may be different under different legislations. I'd like to invite a colleague from the Law Drafting Commission to explain to us the rationale behind. Well, if it is under a schedule, for the Chinese version, we will use the number of the strokes of the Chinese word to decide on the order. For the English version, we will use alphabetical order. But then under schedules, it's different from how we do it under the ordinance per se. The principal consideration is to make it clear and avoid confusion. I'm sorry, I don't understand. You said one is using this and the other one is using that. I'd like to know if you have any consistency. I understand that for interpretation or miscellaneous interpretation, it's easier for people to use alphabetical order. But then we're talking about other legislations and also the schedules to those ordinances. I don't understand when would alphabetical order be adopted and when would the Chinese number of strokes be adopted. Well, if it's under schedules, then for the Chinese version, we'll use the number of strokes to decide on the order. For English version, they would use alphabetical order. But for CAP 41R is a table. So the table should be comparable between the Chinese and the English text. Well, for instance, the order on the Chinese text should be the same as the English text. What about Schedule 3? Isn't Schedule 3 a table? Well, Schedule 3 is not a table, it's a schedule. Well, you're saying that if there's a table under a schedule, that would be regarded as a schedule. And if it's, I really don't understand. Madam Chair, I don't know whether I've made myself clear. All right. Yes, we understand your concern. You're talking about the ordering, whether there should be some consistency. I think the relevant departments should really think about it because Mr. Xie is not just mentioning about this ordinance per se. I think we should give some time to the administration so that they can give us a written reply. Is that okay? All right. Professor Leung. Part 5. Mr. Holden Chow, is a question related to this part 5? And also, Mr. Dennis Leung has pressed the speak button. After they both speak, we will go back to Professor Leung to see whether you have any response to the reply of the administration. Well, thank you, Madam Chair. I'd like to thank Priscilla Leung for raising this point. Well, my view is that if we're looking at 1R, because it's a table. Hong Kong, Macau, Taiwan, because it's within a table. If we just look at the table, if you mention all these places, China, Hong Kong, Macau, and Taiwan, we would understand that you are talking, when you talk about mainland China, that means different places in China, and which do not include Hong Kong, Macau, and Taiwan. So I'd like to know whether this is the usual practice when you mention mainland China within a table. If it is, then it's widely acceptable, and I think it's clear enough. We don't really have to make amendment to the existing term. But of course, on the other hand, if you find that it's not just a problem of Cap 41R, if people looking at these legislation, you think that you believe that it should be clearly stated that China, Hong Kong, Macau, and Taiwan are not included in the mention of China, then if that is the case, I agree that it should be amended. As Mr. Wong has mentioned about an alternative amendment, so my personal opinion is that whether it is commonly used, that if within a table there is a mention of Hong Kong, Macau, mainland China, and Taiwan, then we would understand that mainland China would refer to different parts of China, excluding Hong Kong, Macau, and Taiwan. If this is a usual practice, if it is clear enough, then I don't think we need to make any amendment to the existing use of the term. I'd like to hear from the administration to see whether they have any special views. Thank you. Secretary General, any response? I don't know if Professor Leung also has a view on that. Yes, let's or Mr. Leung, Dennis Leung has any view on that. Let's listen to his view first. Yes, thank you, Madam Chair. When we look at page 16 of the markup copy, table 10, it's about some numbers. Of course, to uphold integrity and the sovereignty of our country, and also we have the special administrative region of Hong Kong and Macau. We also have Taiwan. So we have to be clear. When we look at page 17 and 18, there are also the mention of Hong Kong and Macau. Should we consider all these in one go? For instance, the mention of Hong Kong should be Hong Kong SAR, and Macau should be Macau SAR. That would more clearly specify or more clearly explain the present situation. I think the most important thing is to make it clear and precise and also easily understood, and to avoid confusion. Because they're talking about the statistics, so that is why they want to make it clear that the mention of China or mainland China would not include Hong Kong, Macau, and Taiwan. So perhaps the administration should go back and consider this in one go. Other people will not understand the situation, and the table would then be very misleading, because if it's placed like this, people might think that Hong Kong, Taiwan, and Macau are the same as mainland China, or on the same status as mainland China.
Secretary, do you have any response? Well, this table is kind of an exception because it lists out all the places in China. And this is a table itself, and it covers places outside China. And we have to add them up to 100%. say a foreigner is looking at this table. We want the foreigner to get the idea that Hong Kong, Macau are an inseparable part of China. We've made reference to Professor Priscilla Leung's suggestions, and with the expression I proposed just now, I think we can give people clearly the idea that these places are an inseparable part of China. Professor Priscilla Leung, I first want to know if it is necessary to make the amendment. Well, in English, the proposed amendment is China excluding Hong Kong, Macau, and Taiwan, and I personally find this unacceptable. According to my understanding, normally we use mainland China with M of mainland being the capital letter. And normally it does not cover Hong Kong SAR or Macau SAR. Also, we have mainland of China with M being a small letter, and both versions clearly refer to the mainland of China. I think it is unnecessary to complicate things. We want lawyers, judges, members of the public to be able to understand this easily. If we revise it, it may make things more complicated. Let me look at your suggestion again. That is other parts of China. Is it necessary to have the amendment? Well, can we not make the decision today? Let's look at your written proposal first before we make a decision. I've seen this being used in other occasions, and I remember this expression is used elsewhere. Can you look at where this expression is used? I think we had the discussion about the part of China cover other parts of China. I remember that we have had this discussion before. If it is a new proposal, can you give us more information? Because it covers quite a number of parts. Now I'm looking at the English version, page 2, page 17. Well, you can do the search yourself, and you are proposing the amendments to these pages. If you are to implement the amendment, quite a number of parts of the legislation will adopt the new expression. Is it better to have mainland China? I mean, is it better to keep this expression? I think we should think it through. Well, I thank Professor Leung for the suggestion as well as the detailed analysis. My suggestion is I'd like the administration to give a detailed response in writing. We want to know whether this expression has been used in other legislations. Also, if we are to adopt this proposed expression, will there be any adverse impacts? I think we need to look at it in detail, so please give a detailed written response to members. Afterwards, members or the administration will decide whether there needs to be a new proposed amendment. Now we come to the next part of the bill. Mr. Lee, please. Now we'll look at Part 6 of the bill, the Professional Accountants Bylaws, Cap 50A of the Laws of Hong Kong. Please refer to page 20 of the Chinese marked up copy. There is no consequential English amendment. I'll invite the FSTB to elaborate. Thank you. On the Professional Accountants Bylaws, we are proposing a number of amendments. Please refer to page 20 of the Chinese text for the details. There's mention of the term government, and we made reference to Schedule 8 of Cap 1 of our laws. And the government should cover the SAR government. Therefore, we consulted the DOJ and we decided to amend the reference to the word government to SAR government, and there is no amendment to the English version, and there is only a technical amendment. There is no policy change. Let's look at Part 15 of the bill. It's about the Audit Ordinance, Cap 122 of the Laws of Hong Kong. Please refer to page 79 of the Chinese text and page 88 of the English text. I'll invite Mr. Lee from the FSTB to elaborate. Thank you. We're now looking at Part 15 of the bill. It's about the Audit Ordinance. As mentioned, it concerns page 79 to page 103 of the Chinese copy and page 88 to page 109 of the English text. We are adapting the provisions here so that the provisions reflect the status of the SAR. And there are no controversial amendments here. Before the establishment of the SAR, the appointment of the director is stipulated under this part of the ordinance. After the establishment of the SAR, Article 48 of the Basic Law sets out the appointment of the director of audit. So we are making consequential amendments here to state clearly that the appointment has to be made in accordance with the Basic Law. Article 58 of the Basic Law also stipulates that the SAR government is to establish the audit department. So we are changing the name of the audit ordinance in accordance with the Basic Law. We have the chief executive replacing the term the governor. We are also amending the interpretation of the Legislative Council. There are also technical amendments. For example, we are revising the government to the SAR government. We are proposing some consequential amendments based on the above. For example, we are amending the term the Public Service Administration Ordinance. To put it simply, sorry, I think there are quite a number of amendments. I thank Mr. Lee for the briefing. We'll have to look at the clauses one by one. I see that Professor Priscilla Leung has a question. It was an explanation from a macro perspective. Are we going into the specifics now? Well, please refer to the Chinese marked up copy. It's page 79 of the Chinese copy and page 88 of the English text. Can we go through the amendments one by one? Let's look at each clause separately. Then members will know when it's time for them to raise their questions. Thank you, Madam Chair. Page 79, we propose to amend the long title to stipulate that the appointment of the Director of Audit will have to be done in accordance with the Basic Law. Any questions from members? Please proceed. We are changing the term audit in the Chinese version. Section 2, interpretation. We are revising the term the governor into the chief executive. We're now on page 80 of the Chinese text. Yes. We are adapting the term the legislative council in the Chinese version. Also, we are amending the government into the SAR government, and we made reference to Section 3 of the Interpretation and General Clauses Ordinance when we proposed this amendment. This is a technical amendment. Based on the amendment to Section 5 and Section 10, we are introducing an interpretation to public officers. Now, interpretation of director. Professor Priscilla Leung, you pressed the button. Well, we went through the amendments very quickly. You are looking at the Chinese version. Now, I want to ask about the English text. Please look at the English version as well. We are under the audit ordinance now. I have some comments on page 79. Well, we should look at the Chinese and English version together. So if you have any questions, please raise them when we get to the part. Page 79 of the English text. Section 2, bracket AA, you're amending the People's Republic of China to the mainland of China, bracket mainland. And you have capital M for both mainlands here. So can you please look at this? Sorry, Professor Leung. We are actually looking at part 15. And it is page 88. Did we go through that part very quickly? That's why I missed it. So when will we cover page 79 of the English marked up copy? We're not there yet. Okay, I'll wait for that. We're now on part 15. Page 80 of the Chinese text. We're looking at both the English and Chinese versions together, so it's page 88 of the English text. I finished page 80 of the Chinese text. We now come to page 81 of the Chinese text. That's page 90 of the English version. We are amending Section 3, stipulating that the director is to be appointed in accordance with the Basic Law. We are adding Section 3A, and it is split from the original Section 3 because of drafting reasons. It is amendment based on the adaptation of laws.
Page 82, English version is 91. Page 91, amendment to section 4. It's also an adaptation. It says that the person or the director of audit may be dismissed under circumstances. We're just making some adaptation. English version, page 92, I'll go on. This is also an adaptation regarding salary of director. The chief executive may, by order published in the Gazette, decide the salary. All right. Page 82 of the Chinese version, the word 局长 it seems that different words have been used. Which 取 should be used on the Chinese text? Well, under the audit ordinance, the director here, please refer to page 80. We've made a definition of the director of audit. Can you also talk about the relevant parts of the English text? Yes, English text, page 89. Under interpretation, we have made a definition to the term of director. It's referred to as director of audit. Thank you, Mr. Leung, for your question. I also like to ask similar questions. For the Chinese text, a different word of 取 is used. Under when would you use one, and under what circumstances you will use the other word of 取 in the Chinese text? Well, we follow the term used by the relevant department. And how do the departments decide when to use which word? Well, that depends on what they have adopted to use at the time when they were established. Under the Basic Law, it was mentioned that the audit department had to be established, so we would follow the term used therein. All right, thank you. Chinese version, page 84. English text, page 93. This is section 5. It's also an adaptation amendment. The director's employment as public officer. Legal advisor has already raised some queries on these, so we have replied to the legal advisor about the use of these terms. Page 94 on section 6 is also an adaptation amendment regarding the filling of vacancy in the office of director. Page 85, Chinese text, 94 on the English text. We replace the term governor with chief executive. And the last line, director of audit, we delete the two words of audit because we already have a definition to the term of director, and whenever it is mentioned, it means under this ordinance, it means director of audit. (1)(a) and (2)(f), we make a technical amendment that in Cap 1, the government is referred to the SAR government. 8(2)(e), Chinese version, 立法局 is replaced with 立法會. This is also a technical amendment. Page 87. We have already covered 87. Thank you, Madam Chair. We are now on page 88 of the Chinese text. English copy is page 95. Same as previously, the term government department is replaced with SAR government, the Hong Kong SAR government. Page 90. English version is page 97. Section 10(1), the term governor is replaced with chief executive. Bracket 2, also technical amendment. All members of the director's staff shall be employed subject to such ordinances, colonial regulations, administrative rules, and conditions of service, replaced with public service administration order, government regulations, and such ordinances. Chinese text, page 91. English copy, page 98. Section 11. Bracket 1 and 1(e), we replace the mention of governor with chief executive. 11(1)(a) and (b), government, changed to government, HKSAR government. Page 92 of Chinese text, page 99 of the English version. All right. Page 99 of the English text, section 12 under Audit Ordinance. 12.1b, we replace the Governor of the Legislative Council with Chief Executive. Section 13, President of the Legislative Council, we will cross out of the Legislative Council because we already have a definition of the term President. Page 93 of the Chinese text and page that is on section 12, 2A and 2AA. Chinese term 立法會 is changed to 立法局 is replaced with 立法會. They are adaptation amendments. Section 13, page 101 of the English version. What about section 12, 3A? Oh, the words on the English text of the Legislative Council are deleted because the term President, we already have a definition. President is referred to President of the Legislative Council. So these are just technical amendments. All right, page 94 and page 101 on the English version, section 13, bracket 1. We cross out the words of the Legislative Council because the term President has already been defined as President of the Legislative Council. Page 102 of the English version. Chinese version, government is changed to government of HKSAR. Page 96, Chinese text. 103 of English copy. Section 15 of Audit Ordinance. The governors is replaced with chief executives. 15.1a also, governor is replaced with chief executive. 2a, department, English version is changed with a capital D, is replaced with department with a small letter D. Page 105 of the English copy, section 16 of the Audit Ordinance. 16.1 bracket A and B and also 16 bracket 2. Replace governor with chief executive. These are adaptation amendments as well. Page 99 of the Chinese copy and 106 of the English text. I'm sorry, it should be 101 of the Chinese version and 108 of the English text. World Refugee Year Loan Fund is crossed out. In conducting audit, this loan fund is not covered, so we propose to delete it. Schedule 2, only on the Chinese version, 103. We change the word so replaced with the term 審計. These are technical amendments. English text, some are just applicable to the English text. Shall we go through the English text? All right, on the English copy, well, just now for those you have already covered, you don't have to go through it again. But then there are other amendments that are only applicable to the English copy. Please go through that. All right, English text, page 89. Please hold on. Page 89 of the English text. Accounting officer. Definition of accounting officer. B, the word department is with a capital letter D. We have changed it to small letter d because according to the interpretation in general clauses ordinance, the term department is with small letter d. So this is just a technical change. Similarly, in addition to the definition to accounting officer, on page 95 of the English text, section 9, 1A and 1C, department, we also replace with the department with small letter D. Page 102, English text, section 14, 1 boy, department, also replaced with a small letter D. Page 103, section 15, 2B. The word department is replaced with a department with a small letter D. What about the definition of public money? Only applicable to the English copy. Yes, we just changed the punctuation. English version, page 89, section 2, interpretation under public money. All right, let's move on. Thank you. We have covered part 15 about the audit ordinance. There are some corresponding amendments. I would like to invite Mr. Lee to walk us through. All right, our corresponding amendments. Please turn to page 104 of the Chinese copy about public monies. English copy is page 110. These are corresponding amendments. We cross out under section 3 of the audit ordinance cap 1 to 2 and replace it with in accordance with the basic law. 105 Chinese copy only about the hospital authority ordinance. Page 106, I beg your pardon, we changed the Chinese term hatzhou to samgai. Page 107 only on the Chinese copy. Similarly, section 12, 6. Hatzhou is replaced with samgai. English copy, page 111. Replaced under section 3 of the audit ordinance cap 1 to 2 with the in accordance with the basic law. English copy 111. And lastly, page 109 of the Chinese version and 110 of the Chinese copy. We, on both pages, we replace the term hatzhou with samgai. That's all for me. Thank you, Madam Chair. Mr. Lee? Thank you, Madam Chair. Next, we will move on to part 29 regarding cap 257. Chinese copy, please turn to 153 of the Chinese copy and 152 of the English version.
Thank you. On the perpetuities and accumulations ordinance, we are amending section 3 subsection 4. We have consulted the DOJ and we are proposing an adaptation here. We are revising the crown to the government, and this has no change to our policy intent, and this will not affect the binding effect of the existing legislation. So on page 153, the term the crown will be changed to the government. Please move on. We now come to part 46 of the bill. It's about the Mandatory Provident Fund Schemes Ordinance, Cap 485. Please refer to page 221 of the Chinese text. There is no relevant English amendment. I'll invite Ms. Carol Wong from the FSTB to elaborate. We are amending the Mandatory Provident Fund Schemes Ordinance Cap 485. Please refer to page 221 of the Chinese text. We are proposing to amend the heading under Section 39 of the ordinance. We suggest amending the term court from 法院 to 法庭. Mr. Lee, please. Thank you. We now come to Part 55 of the bill. It's about the Securities and Futures Ordinance, Cap 571, and the relevant subsidiary legislations. Please refer to page 264 of the Chinese text. And for the English version, it's 276. I'll invite Mr. Chen from the FSTB to elaborate. There are references to overseas to describe people or affairs that took place outside Hong Kong. So through the adaptation, we are proposing amendments to revise references to overseas to non-Hong Kong. Please refer to 264 of the Chinese text. This is clause 154. Sorry, please hold on, Mr. Chen. So all the proposed amendments are included from page 264 to page 267, and all the amendments are the same. Please give a consolidated briefing or explanation on this. Yes, for Chinese text, it's page 264 to 267, and for English text, it starts from 276. So we are revising the word overseas entity into non-Hong Kong entity. Please move on. Yes, Mr. Dennis Leung. I'd like to follow up on page 267 of the Chinese text. The revision from overseas entity to non-Hong Kong entity. Would administration make this clearer? Does this cover mainland China? This is my question. Page 267, please. Overseas entity means entities outside Hong Kong, so it would not cover entities in mainland China or in Taiwan. Yes, Mr. Dennis Leung. So is this clear enough? When you say non-Hong Kong, is it clear to everyone that it does not cover mainland China? Cap 186A stipulates that financial regulators can ask for assistance during their investigations. So basically, financial regulators can provide assistance based on the request made by non-Hong Kong entities. So any regulators, regions, or places outside Hong Kong. So it covers mainland China? Right. Professor Priscilla Leung. Well, in the original version, in English, we use overseas. For example, when we say the US is referred to as overseas. And if you say outside Hong Kong, we refer to places outside Hong Kong or borders across. So overseas normally refer to places abroad. So you are changing all these references to non-Hong Kong. When we talk about, for example, citizenship, I think outside Hong Kong has a different connotation. And is non-Hong Kong the best translation here? Say non-Hong Kong entity and non-Hong Kong products sound a bit strange to me. I thank Professor Leung for the questions. Let's go back to the original interpretation. Overseas entity means authorities or regulators outside Hong Kong. Where is it? It's on page 267 of the Chinese text. It's the interpretation or definition for overseas entity. I see that there are other members who have questions. I'd like to extend the meeting by 15 minutes. Do members agree? All right, thank you. I think it clearly points to places outside Hong Kong. So when we revise overseas entity to non-Hong Kong entity, it is just an adaptation. We will not change the meaning of the provisions. I'm just wondering if non-Hong Kong is the best expression available. We had a discussion about nationalities and we had a specific discussion about overseas. When we refer to other countries, we will say overseas in English, and in Chinese, it's 海外. For borders across, it will cover places in the mainland. So I want to give time for the administration to do a search here. So is there a definition for the term overseas? This is just a comment from my part. I just feel that non-Hong Kong sounds a bit strange to me, and I wonder if there is a better expression. We're on page 267 of the Chinese text. The interpretation here refers to places outside Hong Kong. I think in this context, a non-Hong Kong entity is appropriate. But like Mr. Dennis Leung and Professor Priscilla Leung said, I think the administration should look at it from a grander scheme. Yes, Mr. Holden Chow. I'm afraid that I am confused. Cap 571A. It says overseas entity. The original overseas entity, they mean authorities outside Hong Kong. Is it that it does not cover Hong Kong? Well, this question has been asked a couple of times already. I just want to know for the original version. under the original arrangement, when you say HKMA offers assistance to authorities outside of Hong Kong, does that cover mainland authorities? Before we proposed amendments already covers authorities or regulators in the mainland. We just feel that the term overseas cannot accurately reflect what the original provision means. That's why we change it to non-Hong Kong entity. Well, this is clear then. Well, the original overseas entity may be confusing then. It's not right to say overseas entity if it covers mainland authorities. So I think that non-Hong Kong entity is more appropriate then. I don't have other comments. Please move on. Yes, Professor Priscilla Leung. I think it is clear in this context. I think overseas is a sensitive term. In the past, we do not include mainland China when we say overseas. Would the expression entities outside Hong Kong may help enhance the clarity here? Perhaps, Secretary, you can ask the relevant colleagues to reply. I think on the term non-Hong Kong entity, we need a detailed and clearer written response from the administration. Now let's move on. We now come to page 269 to 276 of the Chinese copy. We are adapting the references to overseas market to relevant non-Hong Kong market. And on page 274, we are making a similar amendment. And on page 275, bracket C, bracket II, there is a similar amendment. Please carry on. Now we come to page 277. It's about the securities and futures price stabilizing rules. Again, we are amending overseas relevant market to relevant non-Hong Kong market. Now we come to page 280 of the Chinese text. Again, we are changing overseas market to non-Hong Kong market.
Dr. Priscilla Leung, Professor Priscilla Leung. Right. I think it is clear here. You replace the term with non-Hong Kong. If you make amendments here, would you also make similar amendments to other parts of the ordinance? Or are you just trying to describe the term or give it a qualifier? Because we often use the term outside of Hong Kong. Would you make it consistent? Well, as far as this present amendment is concerned, when we're talking about entities outside of Hong Kong, we mean non-Hong Kong entities, and that's why we proposed the amendment here to make the policy content clearer. I hope that it will include other parts of the legislation as well. All right, point taken. Would the administration perhaps give a clearer written reply, especially on the term of non-Hong Kong, the expression of non-Hong Kong, and also overseas or the entities outside of Hong Kong. Please make a consolidated reply to these queries. All right, thank you. Please move on. Chinese version, page 282. English is 295. Similarly, overseas market is changed to non-Hong Kong market. Blue bill 160, about part 14 of the Securities and Futures Ordinance. Page 283 Chinese and 297 English copy. It's about the amendment to the interpretation of part 14. The term relevant overseas market is replaced with relevant non-Hong Kong market. On your written reply, please also cover this part. Yes, we will do that. Let's move on. Section 2, or page 284, pages 284 to 287, the English version 299. Go onward. About 288 of Chinese text, 302 of English text about offense of price rigging. We also propose to amend overseas market to non-Hong Kong market. To page 291, Chinese text, 302 or 305 of English text, similar amendment. All right, next, 293 of Chinese text and 307 of English text. Replace overseas market with non-Hong Kong market. Please move on. Blue bill 160. Chinese copy 295. English copy 309. On qualified overseas scheme, we will replace the word overseas with non-Hong Kong. Page 297, Chinese text. Also replace overseas with non-Hong Kong, or qualified overseas scheme with qualified non-Hong Kong scheme. 346, page 314 of English copy. Qualified overseas scheme replaced with qualified non-Hong Kong scheme. 301 Chinese version, similar amendment. Bracket 4, qualified overseas scheme replaced with qualified non-Hong Kong scheme. Clause 167, English copy 317. Replace overseas person with person outside Hong Kong. Overseas person will be replaced by person outside Hong Kong. Next, part 2, cap 571N. English copy 318. Under interpretation 1B, UT code relating to recognition of certain overseas collective investment schemes replaced with collective investment schemes that are regulated in jurisdictions outside Hong Kong. Professor Leung? I'm sorry, Madam Chair, I'd like to raise this point again. The ensuing parts just now you mentioned about the different jurisdiction. You said it's outside of Hong Kong. Well, how come in this part you don't use the term non-Hong Kong? Why do you use outside Hong Kong? I think we have to be very careful, because if you change the previous parts and replace it with outside Hong Kong, well, how come under this relevant parts you are replacing it with non-Hong Kong? It's inconsistent. This is just a query. Please go back and take a look. Yes, would the administration please give a consolidated reply to the points raised by members, especially those points raised by Professor Priscilla Leung. Okay, 571W, that is 305 of the Chinese text. It's regarding securities and futures price stabilizing rules. The term overseas stock market is replaced with non-Hong Kong stock market. Blue Bill 170, about disclosure of stabilizing section. Chinese 306, English version 320. Overseas stock market is replaced with non-Hong Kong stock market. I will not repeat myself, but I'd like to say that when we're talking about page 306, we mention outside Hong Kong and non-Hong Kong. So in your reply, please give a consolidated reply on all these queries, especially about the consistency of the use of these terms. Professor Leung, on the Chinese text, 316 and 317, are we on those parts? On that part, you use non-Hong Kong. All right, let's cover that later on. We're not there yet. You could raise your question first. Yes, it's 316 on the Chinese copy. And here you said non-Hong Kong recognized financial institutions. Let's follow the order of the clauses. The meeting will end at 1 p.m. All right. We are on 571W15. This 300 and page 309 of the Chinese version and 323 of the English version. It should be. Please go back to section 12. I'm sorry. Yes, 171. Yes, page 307 about section 12 is to replace overseas stock market to non-Hong Kong stock market. All right, please continue. Section 15, it's on page 309 of the Chinese copy and 323 of the English version. About overseas stabilization, we will replace it with stabilization outside Hong Kong on the title. And 15 bracket A, we would replace the term overseas stock market with non-Hong Kong stock market. Professor Leung? Same question, because you have reached this point. So even on the your title, you are changing overseas to outside Hong Kong. Could you tell us the logic behind that? When you describe Hong Kong, perhaps when you're describing about a scheme or a system, you use the qualifier outside Hong Kong. Is that the logic? Perhaps you should explain it more clearly in your reply. All right. Point taken. Thank you. Schedule 2 about pricing limits. English copy is page 324. Overseas stock market is replaced with non-Hong Kong stock market. Schedule 4 about overseas stabilizer. The title is changed to stabilization outside Hong Kong. If members have no further questions, we will move on to 175. It's on securities and futures, OTC derivative transactions, clearing and record-keeping obligations, and destination of central counterparts rules. Cap 571. Please refer to 314 of the Chinese copy and page 328 of the English copy. We propose to replace the name of certain institutions. That is a kind of adaptation amendment. First, overseas AFI is replaced with non-local AFI. Overseas AMB replaced with non-local AMB. Overseas LC is replaced by non-local LC. Why do we want to use non-local here? Because under the same ordinance, we have description of local AFI, AMB, and LC, and that's why, because we have local organizations, so we want to refer to non-local ones so as to make a differentiation. Professor Lam. Yes, you have non-local except Hong Kong or outside of Hong Kong. Please try to explain your logic behind when you will use which kind of description. All right, I think your point is very clear. Members would like to see a consolidated reply and also to explain to members the logic behind the using of different terms. All right, we are up to page 314 of the Chinese copy. We are reaching to the end of the meeting now. We will pause at page 314 of the Chinese text. The next meeting will be held on the 9th of June, 2 to 4 p.m. That is next Monday. The Secretariat has already sent out the meeting notice to members. Would members who would like to propose amendments please submit them to the Secretariat. That is before the next meeting. To submit your amendments to the Secretariat before the next meeting, please. And for the administration, if you have any amendment or reply, please also submit them to the Secretariat before the next meeting. All right, if there are no A or B, the meeting is adjourned. Thank you.